Hi there, welcome to Fire Away. Today I'm joined by Mitchell Rose, lawyer and mediator. We're going to be talking about mediation and all the tips and tricks you need to make sure your mediation is successful in 2019. Stay tuned. Hello and welcome to episode 13, the Valentine's Day edition of Fire Away, Rudner Law's online Q&A show focused on the employment law issues that matter to you. My name is Stuart Rudner. I'm a lawyer, mediator, and most importantly, your host for Fire Away today. Just a quick reminder, Fire Away streams monthly on Facebook, YouTube, and on our website. If you ever have any questions, we love getting questions live. You can post comments on Facebook or YouTube or tweet them to @RudnerLaw. We'll be happy to answer them if we have time. If you miss an episode or if you want to watch one again, they're always available online after the fact. And today, I'm very excited that in my rant, I'm going to be talking about romance in the workplace and the legal implications of that. Speaking of Valentine's Day, we thought it would only be fitting to offer you a rose for today's episode. In this case, it's not the one you go to the store and buy. It is my friend and colleague, Mitchell Rose, who, as I mentioned before, is a lawyer and mediator like myself. And to make it even better for Valentine's Day, his middle name is Hart. So Mitch, thanks for joining us today.
Thanks for having me, Stuart.
I think this is going to be a great discussion, and our discussion is going to be focused on mediation. Mitch has 20 years of experience as a civil litigator and a decade as a mediator. Like myself, he splits his time between both areas of practice. And although I think we have fairly similar approaches to mediation, today we're going to be talking about what mediation is, what the advantages are of mediation and other forms of alternative dispute resolution, but probably most importantly, some tips and tricks on how to make mediation most successful if you're attending as a party to the process. So let's get right into this. And Mitch, I want to start with a bit of an easy question for you, but there is a lot of confusion out there from people who aren't doing this on a daily basis. So maybe you can take a minute and explain exactly what mediation is.
Well, there's actually no one definition of mediation, but here's the working definition that I like. Mediation is a process whereby at least two sides of a dispute with their legal representatives, if they have legal representatives, come together, usually physically in the same premises, to try to come to a resolution that is better than essentially not coming to a resolution. And they have somebody assisting them who is the mediator, who's neutral in the sense that the mediator has no stake in the outcome, whether or not the case or the dispute resolves or doesn't resolve. And so essentially what the mediator does is assists the disputants with their negotiations with one another. And sometimes a dispute is a legal one, like the one, especially an employment law dispute, like the types of mediations that you and I are often involved in, but it not necessarily. And then a lot of times, mediations can take place in the context of a workplace where some workers aren't getting along, and a mediator may assist them, but there isn't a legal proceeding, yet. Hopefully not.
Yeah, and hopefully we can avoid the legal proceeding if we can settle it fairly early. One important point you made, which is that the mediator, whether it's you or I or somebody else, doesn't have a stake. One question that I often get, as lawyers, we take it for granted. But it's important to note, mediators also have no power. We can't make an order. We're not a judge. No matter how ridiculous we think one side is being, we have no power to make any orders or make them do anything, essentially. And at the end of the day, if they can't reach a resolution, they just move on. And one important point is that, and I'll turn it over to you, maybe you can explain the difference in mediation and arbitration, because that's where people get confused quite often.
Right. I think that's a perfect segue because, yes, the mediator has no power to make a decision. The mediator is a facilitator who's trying to help the parties settle their own case. It's the parties themselves who have the decision-making power, which is one of the advantages of mediation, in that nobody else is going to make a decision for them, whether it be a judge or an arbitrator. So arbitration is essentially, I mean, the easiest, I think, definition is like private court. Instead of having a public judge, somebody who is an employee of the government, make the decision in open court, the people in the dispute have decided instead that they're going to hire a private decision maker, who we call the arbitrator. And Judge Judy, for example, is a perfect example of arbitration. I mean, that's what people are watching when they're watching Judge Judy. It's an arbitration.
You mean that's not real court?
No, and many people may be surprised to hear that, although she was a real judge for a long time. And many, in fact, many arbitrators are former judges, although not necessarily.
Yeah, many arbitrators, many mediators. And
Right.
just on that point, I know we've talked about this offline many times. I mean, it's a real trend now towards Med-Arb or Med-Arb, where it's a combination of mediation and arbitration. So how, maybe you can quickly explain how that typically works, although I know there's some different variations.
Yeah. But yeah, there are variations. I mean, people can't even agree on whether to call it Med-Arb or Med-Arb. So that tells you a lot. Essentially what it is you would pick, well, there are different models, but here's the one I'm used to and you may be used to. Essentially what happens is that the parties to the dispute pick one person as the mediator, and the mediator helps the parties try to settle the case themselves. But if they can't settle, then what happens is the mediator essentially switches hats, switches professions, and becomes enrolled and becomes the arbitrator and makes a decision. That's the simplest form of mediation arbitration. And usually everybody has agreed to that kind of arrangement ahead of time. It's very efficient. You can resolve a legal dispute or another type of dispute very quickly that way. But it has its downsides as well and its controversies, including the fact that the decision maker, the arbitrator, already heard from the parties previously about what they would like to do in order to resolve the dispute. Usually those kinds of conversations are kept private from the decision maker. So judges, for example, don't hear about offers to settle before the trial or during the trial. But in Med-Arb, the person who's making the ultimate decision has heard everything. Of course, that could be a great incentive to settle the case.
Yeah, it can be, but it can be very awkward. I mean, that's one thing when I'm acting as mediator, one of the things I say in my opening spiel is, mediation's like Vegas. What happens in mediation stays in mediation. Right. So don't be afraid to say to me as your mediator, either yeah, it's true, I actually had no reason to fire him, but I just wanted to get the guy out of here and didn't want to pay him. Right. Or don't be afraid to say to me, look, my bottom line is $100,000 because all of that stays here with me. The judge is never going to find out. The problem is if I now flip my hat and become the judge, yes, I know all that. And so one way I know that you're aware of this as well, one way to avoid that problem is to basically have the quote unquote trial first. You do the arbitration first. And I've done this successfully where you go through the whole arbitration process. And it's like you said, it's like a court process. You have witnesses, you have evidence, there are more formal rules. But then what you do is at the end of that, as the judge, the arbitrator writes out their decision, and you can literally put it in a sealed envelope, right? And then you switch hats and become the mediator, and this can be really effective where you're now in mediation. And what parties love about this is, like you said, you're going to have finality that day, one way or the other. You're going to get a settlement or a judgment that day. But the parties also know that usually in mediation we say, look, if you don't settle today, you're going to be stuck in a litigation process. It could be years. It could cost you hundreds of thousands of dollars. In this case, they don't have that luxury of time. It's going to be done today, and they may not like the result. And I've literally sat there, I'm sure you have as well, with the sealed envelope on the table and saying, if you guys can't reach some sort of agreement, we're all going to open that envelope, and you may not like what's in there. Yeah. And the fascinating thing is you almost never open the envelope. You almost always end up settling. And of course, usually one party or the other says, well, just out of curiosity, can you show me what you wrote? And I'm not sure about you, but I never do it.
No, I'd be, as a lawyer, I would be very curious about what's inside that envelope. but assuming we settled. But no, I think, it's more appropriate not to reveal it. That's the whole point, is that the arbitrator didn't make an award, and we call it an award instead of a judgment. And that was all avoided by settling the case. And, so I think the approach that you take is a good one, because it does avoid other problems that can arise along the way, where somebody argues that the mediator arbitrator was impartial. It's harder to do that, obviously, if the decision was already, or the award was already written in advance before the mediation began. So I like that practice, frankly.
Yeah, that's one of the issues. So stepping away from arbitration for a second and just focusing back on mediation, one of the things I struggle with is when I'm acting as counsel and my client, we have a meeting usually to get ready for mediation, then they usually say, okay, so how is this going to unfold? How does it actually work? And usually I'm working with mediators I know their style, but the reality is there are so many different styles of mediation. There are so many different processes. So maybe if you can talk a bit about what you might see at mediation.
Sure. Yes, there are different styles, and then there are hybrids of these different styles, and I'll explain that in a minute. So one style, which is the traditional model, I think, of mediation, is known as interest-based. The mediator, so again, we're not talking about a decision maker, we're talking about somebody who is helping and who's neutral, essentially isn't going to give an opinion about what they think might happen if the case went to trial or an arbitration or some other form of hearing. They're not going to get into that. Instead, they're going to dig underneath, essentially, to uncover what the parties' actual interests are and see if an arrangement can be made. It's like digging below the surface and circumventing all the legal arguments in order to try to find some kind of mutual ground. And this sounds a bit fluffy, but this is really how interest-based mediation works, and it does work. I'd say the polar opposite of that approach is evaluative mediation. And in evaluative mediation, the mediator is usually chosen because they have subject matter expertise. They are usually going to say something about what they think would happen if the case went to trial, or let's say was arbitrated by somebody else. They're essentially telling you who they think is right or wrong, or who stands a better chance of winning or losing, which can be very influential. They're still neutral. They're not interested in the outcome, but you can see that the skill set is different and the approach is different. Now, what many mediators, and myself included, and correct me if I'm wrong about you, that I think you probably have this style as well, is that it's a hybrid of the two.
Yeah, and I think that works really well. And that's one of the things I often tell people is, the value that I bring is I've been practicing employment law for, as someone just pointed out recently, now we're in February, 2 decades since I was called to the bar. So I bring that experience, and I work for employers, I work for employees, I can see both sides, and I can say in the mediation, look, if I was a judge, here's where I would see the downsides or the risks that you have, and here's where I might rule against you, and here's why you might want to consider settling. So that is the evaluative side. But it's interesting because you referred to the interest base as, it sounds kind of fluffy. Yeah. I mean, we've both done the courses in alternative dispute resolution. I've done the mediation courses. I've learned about interest base, and it always sounded kind of fluffy. But I got to tell you, I was at a mediation very early in my career. And I was the junior on the file, and it was a commercial dispute. It was literally about a contract dispute. And the claim was for something like $1 million, and the offer before mediation was something like $1,000. And I sat there, and we started at 9 a.m, and by noon, I think we'd got to the point where the plaintiff was down to $800,000, and we were up to $4,000. And I remember saying to the senior partner who I was with at the time, this is just a ridiculous waste of time. And he said, yeah, you know what, it probably is, but we got to go through the process. And just then our mediator came in, and she was a great mediator who was much more, I think, in touch with people's feelings and interests than many of the mediators. She came into the room and said, I've got it. I've got the breakthrough. I now understand how we can settle the file. And to make a long story short, the claimants, they weren't pursuing this because of any belief that there had been a legal breach of their rights. They were hurt because they thought our client, who was a big company, basically decided to cast them away. And it was right after their daughter had been killed in a car accident. And nobody from our clients had even reached out to express condolences. Our client was horrified. They had no idea about their daughter. We actually quickly brought everyone into the same room, which doesn't always happen in mediation. Our client expressed their shock, their condolences. We actually got somebody from head office on the phone who conveyed their condolences. Once we got all that out of the way, we settled in about 10 minutes. So there is some value to that interest-based mediation sometimes. Sometimes it's about money, but sometimes there are actually underlying interests that are driving the process. So like you said, it's good to have both skills.
Yeah, I think so. First of all, that's an amazing story. And I think if you've been a mediator for long enough or even attended mediations as a lawyer for long enough, you will come across situations, not exactly the same as what you described, but situations like that, where there's this aha moment at some point, usually after a few hours, where you discover as a mediator that this case really isn't about what the legal issues are, or that the legal issues are a stand-in for something else. And that's why switching back and forth between interest-based and evaluative approaches, it can be really useful, because sometimes a situation or even a moment within a mediation calls for one approach, and sometimes it calls for a different one. The only other form of mediation I didn't describe that's popular and that I think you and I don't see frequently is what's called transformative. And the idea is to change the relationship for the better, ideally, between the parties. So you'll see that in workplace mediations, but not in legal disputes usually.
Yeah, that's a good point. You're right. That's not typically a legal dispute where the parties are not going to have a relationship going forward in most cases. But if it's a workplace dispute where the hope is that the relationship can continue, then that's can be critical as well. So as usual, time is flying by. So I want to kind of get to key points. What are your top tips for people going into mediation to make it successful?
Well, yeah, I think first of all, being open just to the concept or to the process of mediation. In many cases or situations, it's mandatory. So, for example, if you start a civil legal proceeding, including wrongful dismissal cases in Toronto, mediation is mandatory, so you're going to have to go anyway. But the thing is that when you actually hold the mediation can be optional. And then a lot of times it's not mandatory. I think in every legal proceeding, mediation is worth pursuing, even if you don't have to. And I even recommend it before a legal proceeding is formally commenced. I think you can save a lot of time and money and risk by doing it. So I think being open to it and having an advocate in your corner who's open to the idea of mediation and settlement is very helpful. Some other things I'd suggest really is to have a realistic assessment of your case done beforehand, together with your lawyer. Before going to mediation, actually consider what are the costs of going forward, especially if you don't settle the case at mediation. What are the risks that you're going to win or lose? Because what happens is a lot of times at the mediation, that's the first time where these kinds of discussions occur. And mediators will certainly help with that, but they can't do all the heavy lifting. So those are two top tips I would suggest.
Yeah, that's really helpful. And one tip that I often give my client, or if I'm acting as mediator, both parties, is I tell them you've got to get past whatever happened before. Maybe you were wrongfully dismissed. Maybe you were harassed at work. Maybe this employee stole from the company. Whatever happened, you're never going to change that. All we're talking about now is probably money, but more importantly, what's the best option for you? And really, if we're talking about mediation in the context of litigation, it's really two choices. You're either going to settle or you're going to go all the way through to trial. So which one is better? And even though you think that this should never have happened, the question is, if you go to trial, odds are you might get, say, $100,000, but it's going to cost you $70,000 to get there, and you might lose. So, how much is it worth to pursue? And from the employer side, same thing. So that's one tip I often give people is forget the past, focus on the options now. The other tip, and this is more for counsel really, is you've got to prepare your client before mediation. I mean, I'm sure you're the same as me. There's nothing more frustrating than arriving in mediation and you've got a plaintiff who thinks it really is $1 million case and a defendant who thinks it is an open and shut cause case and they're never going to pay a dime. And you've got to spend hours getting them to see reality before you can even get into meaningful discussions. So that falls on counsel in most cases.
Yeah, I agree. And, and as I was mentioning before, I mean, that's why doing that risk assessment and knowing the costs beforehand, before the mediation, is so important. You don't want to leave it until the day of mediation. I can't overstate that enough. The other thing I suggest is really and this is also going to sound a little bit fluffy, but trust the process. Mediation, and as you know, Stuart, I mean, mediation it's like an organic process. It has peaks and valleys and beginnings and ends, and things can look very bleak, let's say 3 hours in, but then suddenly there's a breakthrough and the matter resolves, in the fourth or fifth hour. So by trusting the process, it's about being process oriented. If you are a lawyer or if you are somebody who's a party to a dispute, and not focusing so much on what you think the outcome is going to be, because you'll probably be surprised about what the outcome will be, as long as you focus on the process. And you got to trust the mediator to a certain extent, because they're managing the process.
Yeah, and that's why as a mediator, sometimes it seems like you're wasting a lot of time at the beginning, but you and I are developing that rapport. We may well know the lawyers, but we don't know the parties. So you've got to develop that rapport. Otherwise, they're not, people are not going to be willing to accept your views and your recommendations. And, I had one experience about a month ago, I think I told you about it recently, where there were two plaintiffs and we tried to do one after the other, and then we tried to combine them. But the bottom line was that the second plaintiff didn't get her day in court, so to speak. She didn't get the benefit of the process. We just sort of came to her and said, based upon everything we all know, here's a good resolution. But she wasn't ready for it because she hadn't been through the process yet. We had to all just take a step backwards and kind of condense 3 previous hours into about half an hour, but explain to her why we ended up where we did. And at that point, it was successful, but there is value to the process. You're absolutely right about that.
Yeah, and I like your comment about day in court, like having one's day in court, because for a lot of people, being involved in the mediation process and being able to vent, even if it's just to the mediator, even if it's not to the opposing sides, is really helpful. It's cathartic. It does feel like having your day in court. And really, I think the reason why is that somebody feels heard, and we all need to feel heard, like our story has been told and understood. And the mediator really plays that role throughout the process. And people often aren't ready to hear about the law and risk and cost until they've had a chance to talk and feel as though they've been listened to.
Yeah, and I think it's critical. And I've had many clients, and generally it's the employee client, who they want their day in court. They don't really know what that means. That doesn't necessarily mean a trial. It might mean mediation and having the chance to explain to the mediator all the horrible things the other side did. And once they get the chance to do that, then we can move on. So it's critical to have that opportunity. And I'm, again, mindful of time, but we've talked a bit about alternative dispute resolution. We talked about mediation, arbitration. Rob, I was hoping now would be a good time to queue up a video. This is a very alternative form of dispute resolution, but those people who know myself and know Mitch know how influenced we've been by The Simpsons over the years. So this is another way that you can try to settle a dispute.
Wait, that's it. With your book smarts and my ability to exploit people with book smarts, we can figure out a clever plan to get them back together.
A surprise party for me in Principal Skinner's office? Well, I don't know, but all right.
Me? Go to my office? Well, it's highly irregular, but all right.
And you're not coming out until you reach an agreement.
Let us out, Bart!
This is not
Come
funny,
on!
Bart. I mean,
Stop
right
it, Bart!
now,
Let us out right now!
So yeah, when I decided several years ago to start to develop my mediation practice, it never really occurred to me that I was following in the footsteps of Bart Simpson. So with that, Mitch, I know we are again running short on time. Any more tips, either do's or don'ts, that you have for people to make sure the mediation is successful?
Sure. Well, first of all, I think you should ensure that your mediator doesn't lock you in the closet with your opponent. Because that I don't want anyone to. I mean, that's very funny. It's just that doesn't happen. So I think that's key. is actually to be prepared going in and understanding what the process is, what will happen most likely, what will not happen most likely, because people then are more comfortable. They've been prepared for what's going to occur, and what's going to not occur is you're not going to be locked in a closet like that, although it makes for great humor. But I think spending the necessary time as a lawyer, spending the necessary time with your clients to prepare them is important. And also for the mediator at the beginning of the mediation session to also explain the process. It makes people feel more comfortable, particularly if they haven't been through it before.
Yeah, and I think that's key. And I'll tell you something that I've noticed recently, because again, every mediator is different. And it used to be very common to start off with a joint session where all the parties were together in a room. You used to have opening statements. I think most of us have done away with that. But I can tell you, I've gone to mediations recently where I was the mediator, so I hadn't spoken to the parties before. And one party, usually the employee, was literally shaking because she was convinced that she was going to have to sit in the room across from the employer that had been harassing her for years. And as soon as I said, no, we're not having a joint session, you're going to stay in this room, they're going to stay in that room, and I'll run back and forth between them, you could just see the stress just wipe off her face. So to your point, critical to explain the process. Every mediator is different. So sometimes you will have a joint session. But again, I know you're open to discussions before mediation. I am as well. I will be happily talk to counsel before. And if one lawyer says to me, look, my client can't be in the other room with the other party, or be in the room with the other party, we're not going to do it. It's as simple as that. So that's one more tip, I guess, is pre-mediation discussions. There's nothing wrong with them, and they can be very helpful.
Yeah, I'm a big fan of them. Now, when I do have these discussions, they're usually by way of phone call, and they're with lawyers, and the parties aren't involved. That's not always the case with other mediators. It's just that that's the type of mediation that I do. But yeah, that's the kind of thing we talk about. Do you, I say to the lawyers, do you want to have a joint session? And sometimes they say, I do. And then we have to talk about it, and we have to make sure everybody's on the same page about it. And sometimes I actually have to mediate a dispute about whether or not we're going to have a joint session and what's going to be said and not said. But yeah, I think for the most part in employment law mediations, certainly within the Toronto area, joint sessions have become quite uncommon. We tend to just meet in separate rooms, and the mediator engages in shuttle diplomacy and moves between the rooms.
Yeah, and in most cases that works very well. And look, you can always fall back and bring the parties together if you need to. So, and that's another nice thing about mediation. Unlike a court process, it's very flexible. So you can tailor the process to whatever suits the dispute and the parties. So that's about all the time we have. To learn more about Mitch and his practice, you can check out his webpage, which is at www.sgrllp.com, and go to Our Professionals and click on Mitchell Rose, and you can learn a lot more about Mitch. But Mitch, thanks for joining me today. As usual, the time flew by, but it was a great discussion.
Thanks for having me. I enjoyed it.
Now it's my time to fire away. So it is Valentine's Day and love is in the air, but what if it's also in the workplace? Today, what I want to talk about is romance in the workplace. And you can go online and find dozens of surveys out there and studies out there, which will tell you that anywhere from a third to 3/4 of you have engaged in some form of office romance. And a significant number of those have actually led to marriage, which is quite interesting. Best and probably most famous example is the Obamas. As many people know, Barack met Michelle when she was his supervisor at a law firm. Obviously, that relationship worked out very well. Others, not so much. The issue of workplace romance, like many other aspects of employment law, generates some really strong views. You've got people who will say that they should never be allowed. They should be banned outright and absolutely with no exceptions. And then you get other people who say that what two people do on their own time is their own business and none of the employers. And the truth, as it usually is somewhere in the middle. Here's a couple of key points. There's nothing inherently wrong with two people that work for the same organization having a romantic or intimate relationship. Secondly, employers don't have a right to interfere with their employees' personal lives, and certainly don't have a right to cast any moral judgments upon their personal lives. And frankly, as I've told many of my clients, trying to ban workplace relationships, trying to have a non-fraternization policy, which is still fairly common, there's simply no good reason for it, and it's a losing battle that you're probably never going to be able to enforce. So don't bother. But when should employers be concerned? They should be concerned if the relationship is going to impact the workplace. So if it creates a conflict of interest, you got to deal with it. If it prevents those involved or other people from doing their job, you got to deal with it. If there is a non-consensual element or an element of harassment to it, then you've got to deal with it. Otherwise, don't bother and don't worry about it. Don't have the non-fraternization policy, but you need to have two strong policies. You need to have a policy against conflict of interest and a policy against harassment. In the context of conflict of interest, make it clear that you cannot have one party to a relationship that controls the other party's compensation, career path, their workload, their reviews. All of that is offside. And it doesn't matter if we're talking about a romantic relationship or a parent and child or a brother and sister. Those are all conflicts of interest that need to be dealt with. In your policy, you should have a very clear requirement that employees will report any conflict of interest. They don't have to report the fact they're dating their colleague. But if there is a conflict of interest, they must report it. And again, that's only if there is a potential conflict of interest. But if the employee does come forward or the couple comes forward, then you as the employer have to assess whether there is any real conflict of interest. And if so, how you deal with it. Then what you want to do is have the two employees sign off on the fact that the relationship is consensual, that they agree that it will not impact the workplace. They agree that they will abide by all workplace policies. Here's one of the catches, though. You have a policy which says that you must disclose relationships if there's a conflict of interest. But in many cases, people don't want to disclose the relationship. Maybe it's an extramarital affair. Maybe they're embarrassed for some other reason. They don't want to. And at my firm, we've coached many people who have been involved in relationships, and we've told them, look, you've got to disclose it. You're dating your subordinate. You can't do that. But they don't want to because their wife or their husband might find out. And as we advise employees all the time, if that's the case, you have to. The company has the right to know about the conflict of interest and their potential liability. And realistically, as I often tell our clients, if you think that nobody knows about your workplace relationship, you're sadly mistaken. Realistically, people already know about it. People are talking. So this isn't going to come as a shock. And the reality is, it's very unlikely you can be fired for having a workplace relationship. But you probably can be fired if there is a conflict of interest, and particularly if you are dishonest. And there's some famous case out there that I've reviewed in my book called "You're Fired," where people have been confronted, and a supervisor has been asked if they're having a relationship with a subordinate. They were, but they lied about it, and they were given a second chance and lied about it, and a third chance and lied about it, and eventually they were fired. And they were fired not for having a relationship; they were fired for breaching the policy against conflict of interest and for dishonesty. And the termination was upheld because the court found they could not be trusted anymore. So if you're in the relationship, you've got to protect yourself from discipline. You've also got to protect yourself. We unfortunately have advised many people who are stuck in quote unquote relationships that are not consensual. Essentially, it's harassment. And if you're in one of those relationships, you need to get legal advice, and you need to check your company's policy to find out how to report that harassment or that abuse of power. If you're in a relationship with someone at work and as far as you know it's consensual, this may not sound very romantic. You need to document the fact that it's consensual. You want to keep copies of the cards and the notes, and or more likely today, the text messages and the emails. Because at some point, if there's an allegation that it was non-consensual, if there's an allegation that you were harassing your partner, you want to be able to prove that no, in fact, it was consensual and have the documentation. Unfortunately, I've seen many situations where there was a consensual relationship and it ended, and then one party had misgivings or was worried their spouse was going to find out. And the only way they could justify the relationship to their spouse was by saying, I was forced into it. So you have this after the fact allegation of harassment. And if you were party of that relationship, you want to have those text messages which show that they were not forced into it. It was consensual. On that point, critical as employers, as I mentioned before, have a harassment policy. Define what harassment is. Define abuse of power, because you may have a supervisor or a manager who thinks they are dating their subordinate and that it's all consensual, but really the subordinate's only going along because they think that if they don't, they're going to lose their job. They need to be trained on what that means, what harassment can constitute. So have a strong policy. In Ontario, you also have to have reporting mechanisms for reporting harassment, which means having first of all, a primary mechanism and a secondary. So if your boss is also your harasser, you need to know who else you can turn to. to report the harassment so that you're not essentially stuck in the relationship. Bottom line, it is Valentine's Day. Romance is hopefully in the air and may well be in the workplace. There's nothing wrong with a workplace romance. If you're an employer, don't bother trying to ban it. Have clear policies against conflicts of interest and against harassment. Have clear reporting mechanisms that everyone is aware of and make sure everyone's aware of them. If you're in a workplace romance or relationship, make sure you have the evidence to show that it was consensual. And if you're stuck in one that's not consensual, make sure you go see a lawyer and report it. If you're unsure of your rights or your obligations, go see an employment lawyer. I know it sounds self-serving, but as I always say in my episodes of Fire Away, if you think you might need an employment lawyer, you probably do. So feel free to reach out to one. That's my 2 cents worth today, and you got it here for free. So that's all the time we have for episode 13 of Fire Away. I want to thank everyone for tuning in. I want to thank Mitchell Rose for being my guest. Having a rose on Valentine's Day was very important to me, so I'm glad we made it happen. Our next episode is going to be on Tuesday, March 19th. Tune in to our social media channels for more information about our guest and our topic. If you have any questions about today's episode or suggestions for future topics, feel free to email us at info@rudnerlaw.ca. I should know our own website. Past episodes can be found on YouTube, on our website, on Facebook. If you like our pages or subscribe to our channels or subscribe to our newsletter, you'll get notifications about everything that's coming up. We believe at Rudner Law in Education, which is why we do this show. We have our newsletter, we have our blog, we have all of our social media. Take advantage of that information. It's out there, it's free, it's helpful, but it's a starting point. And as I always say, it doesn't replace legal advice. If you think that you might need an employment lawyer, you probably do. So feel free to reach out to us. We'd be happy to talk to you. If we can help, that's great. If we can't, no harm done. Thank you to Rob, to Rebecca, to Mark for making this show go off smoothly as always. Again, thanks to Mitchell Rose. Thanks to all of you guys for tuning in, and happy Valentine's Day.